Forms of action sometimes matter, because they tell you what the underlying cause of action is. Now, if I am right, you interpret this letter of credit as saying, I, Crédit Agricole, promise you, Somo, that I will pay you this sum of money, which will be paid by going into this particular named account. And that gives rise to debt. At the same time, Crédit Agricole, I, Crédit Agricole, promise you, the CBI, that I will discharge my obligation to Somo by paying the money into X account. Now, it happens to be this case that that account is in the name of the CBI, but it doesn't have to be. The promises would be exactly the same, and the results would be exactly the same. And it's important to bear in mind that one of the points on which we are all agreed is that the CBI has no interest, legal or equitable, in either the letter of credit shows in action or indeed the proceeds. At the end of the day, apart from the fact that they are the owners of the proceeds as agents for a period of time before those proceeds are passed on to the Iraqi Central Treasury. I mean, the only role of the CBI in this case is to act, so to speak, as handlers as the money passes along. Now, in that example I've given you, the causes of action are quite simple. Debt between Crédit Agricole and Somo, a contractual promise, which sounds in damages if breached, between the CBI, between Crédit Agricole and the CBI. And I accept that is a shows in action. It is a species of property, obviously, for what it's worth. Now, in those circumstances, let us suppose that Crédit Agricole failed to pay. What is going to happen? Somo is going to sue, and they will sue in debt. And that, assuming they've done their presentations and so on, that will be an unanswerable claim, and they will get judgment for the amount. And that judgment will then be handed over. Let's assume they sue in England. They come over here to sue Crédit Agricole. Here we are, they say. They'll get judgment, and they'll get the money.
Presumably, CBI could join in to ensure the money is not simply paid in debt, but is paid into this account. Could they?
Well,
could they?
I'd be very interested to see how they did that.
Because they've got an agreement that that's what happened.
They would sue saying, you, Crédit Agricole, failed to perform your promise to us to pay the money into this account.
Why couldn't they say you could perform it now, please?
You mean so you would push Somo aside?
No, you wouldn't push Somo
Well,
aside. You'd say you've got to perform your obligation to pay in accordance with what you've agreed with us.
No, because you can only do that if Somo hasn't been paid, and the debt has been discharged to Somo by the judgment. Apart from anything else, as your lordship knows, a debt merges in a judgment. So that has, if Somo sue and get judgment, that's an end of the debt. Now, it is open to the CBI to say, oh, by the way, we're now bringing our additional claim against you, Crédit Agricole, because you didn't pay first time round to this account, we have suffered a loss.
Well, wait a minute.
And we want damages.
What about Johnson and Agnew? The fact that you get an order for specific performance or damages doesn't prevent you from opening it up. Certainly, if you get an order for specific performance, you can say, oops, still want damages instead. I mean, surely if the judgment hasn't been satisfied, it'd be open to CBI to come along and say, look, this judgment won't do. We want it opened up, and we want the money paid into a...
Can we assume that, firstly, the judgment is satisfied?
Oh, if it's satisfied, then
Which and there's no reason to think it wouldn't be.
Then we hit your point, don't we?
You know, because then you see, you get to Lord Hodges' point, which is, where is the loss? Now, the only place in which there would be a loss would be if the judgment is satisfied by payment to Somo in London, and Somo put it in their pocket and run away to Bali and live happily ever after. At which point, the CBI might sue saying, I, the CBI, have suffered a loss, because this money that should have come into this account, in fact, ultimately went into Somo's pocket. And they ran
Why would
away.
that be? Why would that be a loss?
Sorry?
Why would that be a loss?
But sure, it isn't. That's
the
point.
Sorry, my lord, let me finish. The point then is that Crédit Agricole's answer to that would be, but you haven't set up any loss because you had no interest in this money.
But wait, but on one view, you say, earlier, just before the short adjournment, you said, well, under the letter of credit, if they paid it to the wrong person, you wouldn't get an injunction if they're about to do that, because you just say, well, that's irrelevant.
Yeah.
Well, isn't it open to CBI to say, well, it's irrelevant you paid it to say, well, under this, you agreed to pay the money into this account, and you agreed with us. You haven't done it. Do it now.
You agreed that you would discharge the debt by payment into this account. You didn't do it, but the debt has been discharged. You were still in breach because you didn't discharge the debt by paying it into that account, and there would be nominal damages.
And in support of your argument, you can say, in the important words, in compliance with the terms of this credit. Mm-hmm. That you say would support what you're saying
exactly.
in that provision.
But that's documents drawn under in compliance with the terms of this credit, isn't it? It just qualifies
Will
documents.
be duly honoured. Sorry,
Yes.
it will be duly honoured, yes.
Documents will be duly honoured if they're drawn under.
But duly honoured, you say, means honoured in accordance with the letter of credit.
Oh yes, in accordance with the letter of credit. Unless someone decided to negotiate, but in this case, or if there'd been
It's really duly honoured upon presentation as specified.
Yep.
Those are probably the
And then it says to credit. What does that mean? It means by crediting, does it? CBI account.
Yeah, must do, wasn't it? Yeah.
I mean, if
I think
Soma were to sue, presumably Crédit Agricole, if it put its hands up, it would say, yes, we are due you that money, but we discharge our obligation to you by paying it into the CBI account.
Well, if being sued, they said, yes, we should have paid by now, they can pay, and then they've discharged. I mean, they'll be late.
But the point is, if the money is intercepted, as you would have it, in that context, if CBI do not have either a legal or equitable entitlement to the proceeds, what is the content of their claim in damages? At the moment, I see none.
Well, they haven't got any damages, is the short. I mean, theoretically, I suppose they might say they're entitled to nominal damages. I mean, they don't. Sorry, if there has been an interception by operation of law, our submission is they have no damages because the promise to them has not been breached.
Yes.
In other words, the proviso which I put in, or the force majeure clause in the UCP. But if, in fact, the money had gone missing in circumstances where it wasn't justifiable, they could have a cause of action, but they might very well have considerable difficulty in showing any damages because they have no interest in either the proceeds or in the shows of action, which is the letter of credit. In other words, it's a semi-useful promise, this, that was given to the CBI.
You say they have no interest. I mean, there obviously is a general interest, otherwise they wouldn't have been included. They insisted on the inclusion, if you look at the sale contract, or SOMO insisted on the inclusion of CBI. We know it was the background, but that doesn't matter.
Yeah.
If SOMO sued, why could it recover anything? Why couldn't Crédit Agricole say, we don't owe you anything, the most you can get is an order that we comply with the letter of credit, paying CBI?
I will tell you why, my lord.
Yeah.
Because every time a bank does not perform its letter of credit, you sue, you get a judgment, and you're paid somewhere which was not the place the letter of credit said. And the simplest way to look at that is look at Power Kerber. Power Kerber said, we undertake to pay at such and such a bank in North Carolina. They didn't. What happened? the beneficiary sued in the courts of England and got judgment.
Yes, but
and
there wasn't,
presumably
there wasn't,
got
there
money
wasn't,
in England.
there wasn't,
So-
there wasn't a third
No,
party.
I know,
who-
my lord, I know. But
who-
the
there
point
was the
Lord
promise-
Vance was putting
Okay, well, I
was
accept that,
not
but
on
my
that
lord,
basis.
my
So
lord's
you've got
point,
to take it stage by stage. Otherwise, you get into a muddle.
yes, my lord's point is the next stage, though.
Yeah.
Then the next stage is there's been a promise to a third party that it will be paid in a certain way. Now, in my respectful submission, that wouldn't stop the court giving judgment
Well, I would have thought that if I was
to the debtor.
But surely, first of all, the court might say it was appropriate to join CBI, or CBI might apply to join. Secondly, it might be said by the by Credit Agricole, well, I'm not prepared to pay you the money. I accept that if I've got no defence, I've got to pay the money into this account, but I'm not going to pay you.
But, my lord,
Because I've agreed
But
with somebody
why
else.
would
Namely,
that not
it'll put, by paying you, it'll put me in breach. I've promised to pay into this account a third party, namely
I
CBI.
wouldn't put you in breach because you're paying pursuant to a judgment.
Well,
Your submission-
no, I'm just saying before the judgment, I would say you shouldn't give judgment in this form because it's not right. It puts me in breach with
Are you,
CBI.
Your Lordship, putting to me the proposition that the Credit Agricole say, we decided we won't pay in accordance with the terms of the letter of credit, but if you, SOMO, turn up in London, we'll give you 8 million. Is that the
What they're
proposition?
saying is that if we haven't got a defence,
But is that the proposition?
no, the proposition is they would say, and what would be the answer to them if they said, we don't think that there should be a judgment in favour of SOMO. What there should be is an order requiring us to pay into this account.
The court would tell them to get knotted.
Why?
Because that's an extremely stupid thing to do.
But it's what they've agreed to
You
do.
have
Why is
got
it stupid?
a debtor saying, I have not been paid at the place where I was supposed to be
Mm-hmm.
paid. I want judgment. The court doesn't say, the defendant doesn't say, well, you can't give judgment. All you can do is ask for an order, a mandatory injunction saying I've got to pay somewhere else. I have never, ever seen that.
I mean, you've got to test this, surely,
or
by...
indeed in any other form of debt.
You've got to test this by supposing that the bank simply dishonours the letter of credit. It's not that they... let's suppose that that SOMO is perfectly happy that it should be paid into the designated account, but the bank says, no, not going to do that. Now, what happens next is you sue them to judgment. It is inherent in the whole process of litigation and judgment that the nature of the obligation and the manner in which it's performed are going to be different. For a start, you enforce it, not by paying into a designated account, but by walking over to their office building with the bailiffs and putting a green seal on it or whatever they do.
Yes, of course, but the difference here is that what if CBI turn up before they get judgment and say we want to be added because we say that this judgment it shouldn't be a normal judgment, we have a separate commitment that we want to enforce. What does the court do then?
You mean the CBI turns up and
Yep.
say,
Yes.
don't give judgment.
Or give effect to the judgment only by...
Don't give judgment,
Yeah.
to which, after all, SOMA are entitled.
Well, that's the issue. What
they-
judgment
no,
are they entitled to?
Any beneficiary under a letter of credit which has been dishonoured is entitled to judgment. That must follow. It simply follows.
No, that's
automatically.
just
Whether or not there is-
assertion. Surely we must look at the particular contract. This is a very unusual contract, and it's got to be treated on its own right.
It's not that unusual. I mean,
Well-
except the only unusual thing is that you have got an undertaking to the CBI that performance will be carried out in accordance with what the letter of credit says. And I mean, it's no more than the letter of credit saying performance is to be carried out this way, and you are adding a promise to a third party that you will in fact perform your contract.
Just adding a party, it's a tripartite agreement, isn't it?
Well,
Because SOMO are also party to this agreement that the only people to be paid irrevocably are CBI.
Well, before it's tripartite, SOMA were parties to that, because SOMA are only entitled to have it paid in accordance with the terms of the letter of credit. I mean, your starting point is binding both Crédit Agricole and SOMA. This letter of credit can only be performed in one way, and that is payment into this account. Now, all you're doing is adding a promise to a third party that that is what will happen. Now, whether it's done in the document, or whether it's done a day later in a separate contract, or a week or a month, really doesn't alter anything. It doesn't alter the underlying analysis that you've got a primary obligation which lies in debt, and I will discharge that debt in this way, and a promise to a third party that you will in fact perform that promise in that way.
Is it your submission that you cannot get specific performance of a debt? All you can get is a money judgment?
I wouldn't want to go that far.
If you can get specific performance of a debt, then why do you resist the suggestion that that could happen in this case?
Well, because unless someone could persuade the court that there was a reason to give specific performance rather than judgment to SOMA.
Well, the reason would presumably be that
Not really, because
a third-party obligation.
Yeah, but the third-party obligation isn't necessarily going to lead to any loss or damage.
Well, that may be a discretion.
Is the short answer.
Why is the right to recover money linked to whether you would suffer any damage yourself through not having it? I mean, on the face of it, they would suffer damage because the money, if recovered, will be their shows in action against the Federal Reserve Bank.
Had it been paid, it would have been. But it was, they had no interest in it.
Well, that's slightly
They have-
circular.
they-
I mean,
as-
they get a contractual right to it under this. Once it's there, it's their money, part of their assets. It may be they're going to hand it on to the
Something else
Development
is there. Something
Bank.
else is their money. The proceeds have become their money. But they have not, in fact, suffered a loss. Suppose, I mean, just test it this way. Judgment is given, SOMA goes over and collects, and hands the money over to the state of Iraq. Is anyone seriously suggesting that at that stage the CBI marches in and says, oh, by the way, we've suffered a loss equivalent to the value of the money that was paid under the letter of credit, which SOMA have passed on?
Well, no, that's because they've had the effect of the money being paid into the account. I mean, just come back to...
Well, no, they haven't had that effect.
Well,
they haven't, because it's gone to the government of Iraq, not to the CBI, and not into that account. And you see, this is the problem with this analysis,
what about
which is people constantly don't answer the question.
What about you and your wife in the example you've given?
Sorry?
I owe you a debt.
Yep.
You say, please pay my wife. And we enter into a tripartite agreement whereby you agree and I agree that I will pay it to your wife.
Yep.
Now, I fail to pay it, you sue me,
Yep.
and you and your wife have now fallen out.
Yeah.
Why can't she come along and say, well, look, don't pay it to Mr. Pollock, don't pay it to my estranged husband. There's a tripartite agreement, it's going to go to me. Well, surely the court would say...
The answer would be, has she actually got an interest in it?
Oh, well, that's...
But you see...
Are you saying this is an unenforceable arrangement?
If you've gotten a... Well, the whole basis on which this has been argued has been that the CBI has no interest, legal or equitable,
I see.
in the shows in action, or indeed, ultimately, in the proceeds, except that it holds them because it's going to pass them on into the relevant...
Well, it's certainly therefore going to have a legal and equitable interest, unless it holds them on trust, you're suggesting, once it receives them. The proceeds will be its in this account.
The debt owed by the bank, the New York Fed, is a debt owed to it, yes.
Owed to who?
CBI. I mean, they're the holders of the account.
I see, by the Federal Reserve Bank.
The Federal Reserve Bank owes a debt to the CBI.
And, I mean, somebody may enter into a contract to receive some money or some asset, even though they are actually acting as agent for a third party or going to pass it on to a third party. They still have an interest in enforcing the contract.
Exactly. They still have an interest. My lord, with great respect, my lord, that is an intellectually lazy comment. What interest?
characteristic.
What interest? I mean, let's go back. Let us go back to my wife example. I sell my car. Buyer's going to give me £100. My wife's there. We agree to meet at the pub that Saturday for the money to be handed over. My wife says to him, "Oh, careful. He'll immediately go next door and put it on the horses. I would like you to promise that you will actually put the money into my hands, because then I'll make sure it goes into his bank account rather than going on the horses." Now, I don't perform that promise. She has no interest whatsoever in that money. She has suffered no loss. I've broken the promise, and if in fact I give it to her husband and he loses it immediately, I've discharged my debt. So you've got to be very careful when you use the word interest. She has an interest, obviously, in my handing it over to her because she wants to prevent her husband wasting it. But she doesn't have an interest recognized by either law or equity as giving her some form of proprietary interest which would entitle her to say, I have been damaged, or I have something that I can enforce. And that's what you have to keep looking for.
Does it have to be proprietary for this purpose? Let us suppose you take the very common arrangement under which a bank requires payments of salary, for example, to be made into the customer's account with that bank because they've given him an overdraft facility. Yeah. So there's no proprietary interest, legal or equitable. There's no charge over the funds. There's a pure contractual right to require the money to be paid.
As between customer and bank?
Yes, but I mean, it would make no difference to the analysis, would it, if the employer paying the salary was also party to this arrangement. There'd still be no proprietary interest in the debt for the salary. So there would be a purely contractual claim.
The person who is going to pay the salary,
yes,
makes a promise to the bank.
He joins in an arrangement.
He joins in the arrangement.
Under which
that's common. It's quite common, and that sometimes leads to an equitable interest, or at the very least, it leads to the situation where a breach, you could prove damages.
That's true if the account was overdrawn.
Well, indeed, if the account is overdrawn.
Sounds irrecoverable. But I mean, I cite that simply in order to make the point to you that you can in fact have a relevant interest which is not proprietary but purely contractual.
I agree, you can have a relevant interest.
It might be surprising if a third-party interest was enforceable were it to be proprietary, but not if it's to be contractual.
You can have a contractual interest, but it will lead simply to a cause of action in damages for such loss as you can prove. Now, in the example your Lordship has given, it may be that you can prove a loss, because if the account's overdrawn and the customer goes bankrupt, the bank is in a worse position than it would have been had the promise been honored. But if you're in a position where the customer remains entirely solvent, the overdraft is paid off, and nothing has happened, end of it. Nor in those circumstances could the bank intervene and try and stop the customer from paying somewhere else by saying, intervene so as to attack the third party who was going to be paid the money that should have been paid into the bank account. You might be able to injunct the customer, yes, because you're about to breach a promise you made. But that is simply an enforcement of the contractual promise. So you have to pick each of these examples and each situation apart quite carefully to see what the cause of action is and what is a promise, what is proprietary, and who owns what. So if I could just say, my Lord, the general rule, as I have understood it, is that the courts do not make an order, an injunction, ordering the payment of debts. There is an authority to that effect. Mr. Justice Dyson, in a case called Macob, said we don't usually do this, But he doesn't say it could never be done. So I can't go as far as to say it's not open to a court to make an order that a debt should be paid, if there's a reason for doing so. But it's very, very unusual in my suspicion.
Yeah, that sounds a very likely. It's actually correct, yeah. That it's a
my
very
respect.
unusual course, but it's not one you can't take, yeah.
It's not one that would be undertaken unless there was a reason for it.
Oh, yeah.
And so in a case such as the present, unless there was good evidence that Somo was about to depart with the proceeds, no one would do it. They'd just give judgment. Now, I may come back, my lord. I may go hither and yon a little bit. I tried, in this case, to write my reply in advance in typing because I was hoping I could do what Lord Sumption used to do, who once told me that's what he did when I said to him in surprise, "How come your reply is all typed out?" But I'm not as successful, I'm afraid. Some of it is typed, some of it's going to be on the hoof. So anyway, can I just look for a minute at Proposition 2 that Mr. Dunning put? You have to inquire into the relationship between CBI and SOMO. Is the judgment debtor entitled to dispose of the debt? The answer to that, I can be very brief in my respectful submission. What happens to the proceeds is neither here nor there. The only question you ask is, was SOMO the owner of the debt at the time at which we seek to seize it? If the answer is yes, then you don't have to inquire any further. If the answer is no, that's an end of it. And any other approach would be extremely far-reaching because a state could simply set up an independent trading company, but immunize that trading company's assets forever by simply proving that the internal arrangements in the state mean that the trading company would hand over the assets once received, and that cannot be right. Now, interference with immune property of the CBI, my lord, all you need to do is to analyze it. The property of the CBI, which is being interfered with, on the analysis on which this proceeds, is a promise, not a debt, because we've agreed it only arises if I am right that the debt is owed to SOMO alone.
Yep.
My learned friend says that what is being interfered with is a shows of action in damages. There is no such thing as a shows of action in damages. There are shows in action which are debts. There are shows in action which are contractual promises. If a contractual promise is broken, it may give rise to damages. The only time a shows of action in damages might be dealt with is when I have obtained damages or are entitled to damages and I assign the damages to a third party. I am assigning that right. But what we are dealing with here, the property which is being interfered with, if any property is being interfered with, is they promise that the debt will be discharged in a certain way. There are no damages yet at all. If that is frustrated by interception, no damages will arise arise. And you really don't need to say anything more.
So it's really the same point, effectively.
Yeah.
The analysis, if you're right on the analysis, gets you home on the first point.
I think Mr. Dunning accepts that. I think he accepts that if that is the true construction, that's what follows. He says it isn't the true construction, but that goes back to an earlier stage.
Then you're dealing with something different,
No, I think...
which doesn't really help.
Mr.
Now,
Not sure Mr. Dunning does accept.
If I could just intervene, I did accept it on my Lord Sumption's construction, but I'm not sure that that is the same construction necessarily as being advanced. I was making the point on the hypothesis that the correct construction was Lord Justice Moore-Bick's construction.
Thank you.
Now, I would suggest that an easy test as to how one might look at the letter of credit, if just going back to the question of construction, suppose the CBI alone sued Crédit Agricole for the debt because it hadn't been paid. what would Crédit Agricole's automatic defense be? We never undertook to pay you anything. The debt is owed to a third party. I know that's repeating myself, but it is an easy way to put it.
Yes, I see.
Now, let me... General horticultural, if I can mention that very briefly. As was said, I think, by one of your lordships, notice simply deals with priorities between existing equities and was irrelevant in that case. What matters from that case is that you are not entitled to alienate property as between yourself and a third party and then give that property away to someone else because you have created an interest. Nothing to do with the priorities. You simply then subsequently seeking to give away what you no longer have. And that is all that case says, and it gets us no further. Lord Justice Morbick was right about that. Mm-hmm. Now, I'm not going to mention the note verbale. Can I deal with citus?
Yes.
Now, whenever you ask yourself the question, where should the citus be located, the residence of the debtor or the place of payment, you are weighing up two sets of competing policy considerations. And the reason that English law adopted the place of residence of the debtor was because there are powerful policy considerations in favor of that. And they are, one, it's easy to get jurisdiction. Two, it's easy to identify in the usual case. And three, it is easy to execute. In other words, it's where the debtor will be, where he will have his assets, and where you should have very little difficulty in enforcing your debt. Now, all of those considerations matter in the case of a letter of credit. After all, a letter of credit, my friend says, is very important because it's the equivalent of cash. Yes, it is. And it's the equivalent of cash when it's performed. But we are dealing with the situation where it isn't performed. And therefore, you have to say to yourself, what are the relative advantages as to where you put the citus in circumstances where the letter of credit has not been performed and it is necessary to sue? And in that case, all of the advantages that relate to debts relate equally to letters of credit because you are now simply looking at a debt. And you have got to find some reason why a letter of credit debt is different when you are suing on it after dishonor in order to say that you ought to depart from the rule. And the list of issues that my friend gave have nothing whatever to do with that. He says irrevocable as soon as it's issued. Well, he's not quite right. It's irrevocable once it's been notified. But nevertheless, he's right, it's irrevocable. But he's equally not quite right about that because it can be discharged by agreement between the beneficiary and the bank, just as any contractual debt can be altered or discharged by agreement between the creditor and the debtor. So saying that it's irrevocable doesn't mean anything in terms of the argument we're having. He's saying it acts autonomously. Well, that's got no relevance to the question of where it is best for you to be able to see where the situs of the debt is if you have to pursue it. He said it's triggered by the presentation of documents and nothing else. Well, what has that got to do with where the debt should be cited if you're having to sue for it? Nothing. It's simply any contract which involves debts will usually have conditions which have to be satisfied before the debts arise. Only evidence of fraud can prevent them from being operated. Well, often only evidence of fraud can prevent various things arising under a contract. So what? And then he says, English law regards letters of credit as being governed by the law of the place of payment. Now, he said that, and he cited a number of authorities to your lordship. But you've got to be a little bit careful about those, because those were cases where you had one specific place where you had both presentation and payment. And what those cases decide is that where you have presentation and payment at the same place, that is the characteristic performance. Now, we don't have that here. We have here an entirely different case where presentation takes place at the counters in Baghdad. The documents are examined in Baghdad, and they are certified as correct, one believes, by the CBI, who then send them to London, where they're received by Crédit Agricole, who look at that certification and check for themselves that the documents are correct. And then, having decided that they are, they then go through that process which we have seen of sending a telex instruction to their New York agents in order to pay. Now, that is very, very different from those cases which we looked at. And if
those cases being Bank of Baroda and Marconi.
The ones that were, he cited at the end, my lord, Marconi and Baroda and so on. And those were in any way complicated cases, because often what was being argued in those cases was the question of where the confirming contract was to be, what law the confirming contract. So they're a bit more complicated. And in my respectful submission, there is no accepted rule that when you have various aspects of performance spread out over a number of jurisdictions, that the last performance of where payment takes place is to be accepted as the one that tells you what the governing law is. I mean, the other side have argued in this case, and argued strongly, first instance, that Iraqi law was the governing law of these letters of credit, because you had an Iraqi seller, you had the Central Bank of Iraq, you had presentation, it was notified through the Central Bank of Iraq. They said it's Iraqi law. Alternatively, they said New York law. Now, there are different aspects which you can pray and aid. But this is important because it leads you back to Rome 1. And Rome 1 says, a characteristic act of performance, which both Mr. Justice Field and the Court of Appeal, through Mr. Justice Lord Justice Moore-Bick have said, takes place in London because of the examination of the documents and so on. And my friend says you should displace that, but the displacement requires you to come to the conclusion that there is a manifestly closer connection than London, where that characteristic act takes place, with New York. But the answer is nothing much happens in New York. A lot happens in Baghdad, a lot happens in London, and as I said in opening, all that happens in New York is that you get, put it at its highest or lowest, some zeros and ones pass through the ether, and the result is you have credit balances that alter within a system. Now, is that particularly important? Certainly. The letter of credit said that that the ultimate end of payment was for a credit to arrive at a certain place in New York, but that was a comparatively minor last act. And so we would say that Lord Justice Moore-Bick was absolutely right, and he was entitled to say what he did on the basis of applying the Rome Convention and the Rome regulations and saying there is no connection here which is so manifestly different from the residents of Crédit Agricole that we are going to depart from the usual result. Now, so continuing, so with citus, you ask yourself, those various features which my learned friend listed and said these are all point as policy in favor of saying the place of payment is the citus. None of them point as a matter of policy to that being the case. The policy question you have to ask yourself is, where is it best for the beneficiary to be able to sue? Where is it best for him to find citus? And in our respectful submission, that is where the bank is to be found. Now, we get various examples given by my friend. Well, suppose you've got a nasty little bank somewhere whose courts may do wrong things and this, that, and the other. Those are minority cases. The majority of cases, you will have first-class international banks cited in first-class international centers issuing letters of credit. And there is an enormous advantage to the seller to be able to say, I can go to this bank in this financial center, in this civilized country, Germany, France, England, New York, where the bank lives, get judgment and collect. And that, with great respect, is a lot more powerful at the end of the day than saying, well, it all depends on what particular place a payment was supposed to take place, which could be anywhere, scattered around the world, where people happen to be. Now, if a seller is concerned, if he's got any concerns about his ability to collect, the well-known and obvious route is to require confirmation. And if your lordships think back at contracts that your lordship has seen, time and time again, contracts require a confirmed letter of credit, and the confirmation has to be from a first-class bank, and often it is specified which, well, one of which financial centers it should be. So if you're worried, that's what a seller does. So in my respectful submission,
would in any event it be open to a seller to say, I will take a letter of credit, but I will take it from Bank X?
oh yes,
So the mischief can be dealt with in the contract,
Yeah.
even, quite apart from the confirming bank.
Exactly.
Yes.
Exactly. But what one has seen not infrequently in cases of state oil companies is they allow the buyer or whatever to choose his own local letter of bank, but they insist on confirmation, and it has to be a first-class bank cited usually somewhere in Europe or in North America.
Yes, well, what people have been doing may have been done on the basis of the case that you're asking us to overturn. But the point is, if we do overturn it, then different contractual arrangements can be made to secure the fund.
Well, I'm not sure that my submission would be that no one would alter their practice because they already have satisfactory contractual
Through the confirming bank.
through the fact that if you don't like the bank that might be used, you ask for confirmation.
Yes.
But I mean, in this particular case, you didn't need confirmation in this case because Crédit Agricole is a first-class bank, and you know where to find it, and you know where to collect the money if you need it.
Thank you.
I mean, Singapore, my friend said Singapore is just used as a matter of convenience by Shell for booking its oil contracts. I mean, it's all done out of London. You know, Shell Singapore is the company they use. So in our respectful submission, there are no good policy reasons for choosing the place of payment over the residence of the bank, whether that be the issuing bank or the confirming bank, and there remain good policy reasons the other way. And there is, as I suggested in opening, in the Power Kerber case itself, the clearest possible example of the policy reasons in operation, in that the seller in that case could not collect at the place of payment, could not get jurisdiction in the place of payment, could not find the bank in the place of payment, and had to go forum shopping in order to find somewhere where it could sue.
Yes.
Now, receivership, my lord. Can I just make quite sure your lordships understand the background, because my learned friend was a little bit misleading on this. The way you enforce a judgment, an arbitration award under section 66, is you ask for leave to serve out of the jurisdiction. That, as your lordship knows, is done ex parte. And the White Book says that you are pretty well entitled to it if it's an arbitration award case. So we got leave. We then set about serving that. And it was served through Vincent Elkins on the other side. So they were properly served. We then got ex parte an interlocutory TPDO and an interlocutory receiving order. And it's those interlocutory orders that we're fighting about now. And the reason why you get them on an ex parte basis is the same reason you ask for Mareva on an ex parte basis, because you don't want to see the carpet whipped out from under your feet. So we get an ex parte order, at which point the other side enter an appearance. And as your lordship knows, when you enter an appearance, you have to say whether or not you are disputing the jurisdiction of the court. And the other side ticked this box. And when you do that, you
Tick
have
the box what? Say that they were disputing.
that they were. And when you do that, you have to say why you're disputing the jurisdiction of the court. And the relevant box, can you just get me the form out they ticked, says quite clearly that if you dispute the jurisdiction and lose, you are then deemed to have submitted to the jurisdiction. Right, round one in this punch-up was their disputing the jurisdiction.
Right.
And the sole ground that they put forward was that SOMO was an emanation of the state of Iraq and therefore immune from the jurisdiction of the English courts.
Right.
That was fought out in front of Mr. Justice Field, who said, no, you aren't. It was run again in front of the Court of Appeal, who said, no, you aren't. Right. And it has been abandoned. Therefore, the sole ground on which jurisdiction was challenged has been lost, and the net result is that they have therefore submitted to the jurisdiction. They have at no stage... Yeah?
Do you not get another go?
Right,
Sorry?
I thought under the rules you got another go.
Sorry?
Well, under some of the rules anyway, I thought that if you challenged the jurisdiction and lost, then you had another opportunity to enter an appearance.
No, I don't think so, my lord. At least that's not my understanding.
I thought so. I thought we didn't put people to sudden death.
Well,
I might be wrong about that, but
I mean, you're asserting it. We haven't got the rules. Is that right?
no. Well, what I do know, what I can say is that the only ground on which they challenge the jurisdiction...
I think Mr. Dunning pretty clearly doesn't accept what you're saying about the only ground of objection. Is that right, Mr. Dunning?
Well, I've put the letter
Sorry,
in
my
front
lord,
of Mr.
let me put it quite plainly. What they have done is they have challenged the jurisdiction in two ways.
Right.
They have said, you can't do anything against us because we are an emanation of the state and therefore immune.
That was the point.
Then they have said, you don't have jurisdiction, and this is a misuse of the term jurisdiction,
Right.
to make these orders because you are violating section 13.2b. And inter alia, they're the property of the central bank.
And you say that's not an objection on...
Now, that's not an objection to the jurisdiction. That's saying you can't execute because there are two different immunities that arise under the State Immunity Act. Immunity from the adjudicative jurisdiction and immunity from the execution jurisdiction. Now, they effectively ran both in relation to SOMO and have lost. They have continued to say in relation to the CBI. Not that there is no adjudicative jurisdiction, because the CBI are not impleaded. What they have said is, either this is the property of the CBI, in which case it is immune from execution, in which case you discharge the orders, because they are orders simply in relation to execution, or they say, their current argument, which is you give a wide meaning to property and so on. But where we are left, and this is very important that we do understand this, is that SOMO are subject to a final and unchallengeable judgment. Judgment has been given by the English court in the amount of 8 million and something against SOMO pursuant to Section 66. And that judgment is final, and the jurisdiction to give that judgment is unchallenged and now unchallengeable.
And the State Immunity Act point goes to execution, not to judgment.
Yeah.
That's your point. Yeah. Yep, okay, got it.
I mean, the truth of the matter is, my lord, that state immunity, except at the initial point, was SOMO and emanation, has dropped away. My friend keeps saying it's relevant to the CBI. It isn't. And I thought I'd explain this in opening. If this is property of the CBI, the letter of credit debt, either sole or joint, immunity doesn't matter. You're not allowed to execute against the property of someone else than the judgment debtor, or property that is owned jointly. So immunity is simply a red herring, and has become a red herring. That's all. It's pretty straightforward. So when we look at the receivership, the position is that you have a party, SOMO, properly before the court, has not challenged now being before the court, and that judgment is final. And it is in those circumstances that I made my points about the policy of English law in relation to the enforcement of arbitration awards, none of which points my friend has sought to controvert. And my point was that when you have that situation, then you have the necessary contact with the jurisdiction. And I need not repeat those points. Now, in my respectful submission, one could simply say this, I suppose, rhetorically, in closing on this issue. I'm going to win my bet, 3 o'clock. My second bet. What harm does a receivership order do to anyone in this case? And the answer to that is the only person harmed by the receivership order would be SOMO, because it prevents SOMO from avoiding their just debts, and it prevents SOMO from honouring a judgment which has been given against it and which is neither appealed nor challengeable. Now, in those circumstances, you say, why should the court hesitate if the only way that execution can be carried out is via the equitable receivership use in letting that order stand? Now, your lordships did ask, well, what benefit might it do? The short answer is, we get our money.
What do you say about the?
Because it's in court.
What do you say about the submission of Mr. Dunning that the receiver cannot do anything which would not be contractually open to SOMO?
That is an interesting theoretical question, my lord, which I'm bound to say I just don't know the answer to, because if you go and look at the books, they don't tell you. But it doesn't matter in this case, because the money is in court.
But that's
and if the receivership order becomes final, it will come out to us because Crédit Agricole are happy that it should. And therefore, in this particular case, we get our money. And whether in a different case we wouldn't have been able to make much use of the receivership order is really neither here nor there. The question is, in this case, is there a good reason to make it? And the answer is, once the money is in, it having been made, the order should stand, because that is the only way that it is going to work. Crédit Agricole still have the right to come and say there are problems here. Our lawyers have told us that New York will make difficulties. No one has ever suggested that. And if that happens, that's our risk. If the only way we get there is at the end of the day, the receivership order doesn't do us any good, well, that's a risk. But at the moment, it looks to us as though it's going to do us good. And for that reason, we should be allowed to keep it unless there's an overwhelming reason. Sorry, my lord?
Where did Lord Justice Morbick go wrong?
Well, the reasons I gave you.
Okay, well,
I mean, do you remember the reasons he gave, my lord? Just let me find the judgment.
There were three reasons, one of which was in your favour. There were really two reasons which you...
He was in our favour on the second reason.
On the second, but not the first.
But not the first and the third. Now, his first one... wrong. Here we are. Sorry. Yeah, here it is. Paragraphs 29 to 38.
Yes.
And his first...
It was 33, 34 and 35.
His first reason...
36.
33 was Somo had no connection. Well, I've dealt with that. I'm right or wrong on that, and you've heard me. So we say he was wrong on that, not to recognize the connection. Second point, exorbitant jurisdiction, we win on, and we say we were right to win on that because he was right on what the proper law was, and even if the proper law is different, it still wouldn't be too exorbitant. And his third point, paragraph 36, the effect of the receivership order on other parties, in this case, principally the CBI. Now, if Somo owe us money, and if the balance of the letters of credit are discharged by us being paid with money that Somo owes as a result of its oil trading activities, how does that damage the CBI? What have they lost? I mean, the suggestion appears to be that the CBI, as representative of the state of Iraq, should benefit by receiving money which Somo ought to pay to us and which arose out of the very activities which are designed to pass through the oil proceeds account and then back into the coffers of the state. Now, why on earth is that a reason for refusing the receivership order? Great respect. Simply, in my speculation, you can't see it. I mean, it's effectively saying, if you have a method of judicial execution to give effect to an English judgment, because that might affect a third party who hoped that the proceeds would pass into their hands, although not to be owned by them, then you should refuse to go ahead with execution and enforcement of the judgment. Now, that is not a policy. Those, my lord, are my submissions in reply.
Could I just ask you one, just to be sure that I've got this right, going back to the letter of credit,
Yes, my lord.
just make sure that I've understood exactly who's who in relation to all of this. The, on page 54, first page,
I just got to find my version. Here we are, I've got it. Yes, page 54.
page 54, the first page of the letter of credit, just looking at who's who as you go down, please advise our following. That's Credit Agricole, is it?
Credit Agricole saying, please advise our,
Yeah,
that's
yeah.
Credit Agricole, following irrevocable documentary credit to an oil marketing company,
To Somo.
Somo,
Right.
after adding your confirmation. Our reference, yeah.
Now, then the invoice, which we still have, we haven't seen the invoice, have we? The original invoice. That would be an invoice from Somo to
Have you got one?
Shell.
Shell, yeah.
It will be an invoice
From
from
Somo
Somo,
to Shell,
addressed to Shell.
addressed to Shell. Right.
Sorry? I don't think it's in the bundle.
No, okay.
I'm told.
Then I don't think there's any difficulty on the rest of page 1. If you come to page 2,
Yeah.
I don't think there's really any difficulty down till the two clauses we've been discussing, or much discussing, under the provided that, provided all terms and conditions and so
Yep.
on, irrevocably paid into that CBI account, is it?
No.
No.
Who's
You
Because
say it's,
provided all terms and conditions of this letter are credited, proceeds of this will be irrevocably paid. This is a promise being made to the beneficiary,
Yeah,
and therefore your account is effectively your nominated account, your account, SOMO's account.
but you're accepting that SOMO can nominate that account to be CBI's account, as I understand it. That's your
SOMO can nominate, SOMO can ask for any account
But
they
for
like.
you're reading your own or your nominated.
Yeah, your account is simply shorthand for the account you have nominated.
That's the point.
Yeah. And that has been nominated in the draft that's been sent effectively to Secretary Agricole to issue.
so your account is that CBI then? I mean, it's SOMO's account.
What you're saying, as I understand it, is
It is
the account which you nominate
the account which you had nominated for payment.
for payment.
You have to read the two paragraphs together, do you?
Sorry, is that?
You have to read the two together, the paragraphs. Your
Then you
account-
go on, we hereby engage
Yes.
document transfer
Yes.
with duly on it as to credit CBI and so on. Well, you don't repeat your account there.
No, what I'm saying is the reference to your account means, according to you, the account you have nominated, and that then is further identified in the next paragraph.
Yes.
Yes.
Yes, yep, that's to understand.
Well, yeah. Well, oddly enough, it is named as Iraq oil proceeds account,
Right.
which is in fact the CBI account with the Federal Reserve Bank of New
Well, that's
York.
what I meant.
So it's just been
Lovely.
it's sloppy
Which
short.
is it's the account which you have already
Yeah.
nominated.
Yeah.
Yes. And then the seller in the last line, who's that? That's SOMO, is it?
The seller's commercial invoice is SOMO,
Yeah. And then we hereby engage with the beneficiary, and that's SOMO, or not?
and that's SOMO.
So you, beneficiary, and seller are all SOMO.
And beneficiary is SOMO throughout.
Yes.
You, beneficiary, you, or your beneficiary and seller are
All SOMO.
Clearly, beneficiary and on any view, beneficiary and seller are
Yeah.
they?
Right.
And then you becomes Central Bank of Iraq when we come to the third page because they are special instructions to them.
Well, indeed.
And that
But hang
heading
on,
is
those special instructions are when the Central Bank of Iraq has negotiated payment itself.
upon receipt. Yeah.
I mean, the special instructions are almost certainly on the assumption that there will be confirmation.
I think that,
Because the special instructions say, authenticated telex confirming that you have taken up documents in
Yes.
conformity. We undertake to effect payment at maturity as provided that such is delivered, blah, blah, blah. And then if our cover does not reach you in time, because you've got to read the next one into that.
Right.
And that means our cover to cover you for having paid against the documents.
Yeah.
Which never happened. So the truth of the matter in that case, none of that matters.
That's fine. Thank you very much. I just wanted to make sure that I got right who was who, and who was you, and who was what. Thank you very much.
Any more?
Good. Well, thank you all very much indeed. Thank you, Mr. Dunning. Thank you, Mr. Pollock, for your submissions. Thank you very much also to everyone involved in preparing the written cases, which we found very helpful. We will consider this interesting and well-argued case and let you have our decision in due course. Thank you all very much. Court's now adjourned.